heard you said be specific as far as the relationship, what I have to say to Sydney Hanlon. I would just ask you to bear some patience as far as stating some facts as far as years and individuals. In 1995, I believe that Sydney Hanlon should not be appointed to the appeals court. That she lacks integrity and partiality requirements of a justice of the district court, let alone with the appeals court. For more than a decade, I've been a victim of a campaign of harassment, persecution, malicious prosecution, constitutional rights violations under leadership, guidance, and instructions of Sydney Hanlon, largely due to my opposition to the discriminatory practices of the issuance of restraining orders under 209A in the Dorchester District Court. It all began in 1995. I ended a relationship with an ex-girlfriend. On account of her threats, I attended a restraining order, put the court on notice that I was concerned about physical conflict. Plus, in the relationship, she was physically abusive. I finally got a restraining order on February 8th of 1995. In violation of Section 3 of the statute, the next day they issued a restraining order to the ex-girlfriend. Under the instructions of the clerk magistrate at the time, Mr. James Buckley, I filed a letter to the appeals court stating that I wanted to appeal the restraining order. They took it as an appeal and denied it. Immediately after, in May of 1995, the ex-girlfriend filed for a dismissal of the restraining order. What has been, I would further expand upon common practice in the district court, Dorchester District Court, is I wasn't notified of the hearing. When I didn't show up, she was granted dismissal. Immediately, I became the subject of complaints of telephone calls and driving by the house. The end result of everything in 1995 was that I was given a permanent restraining order issued against me, again, in violation of a firm case law. I lost my firearms. I was in the military for 9 years. I am not a firearms buff, but I believe in support. I believe in the right to carry firearms. And to this day, according to the rules of appellate procedure, I've never been given an opportunity to appeal the restraining order from 1995, and every effort has been made to deny me the right to appeal this restraining order. It was discovered several years later that all the tapes that I had ordered were either blank or they were doctored and edited. That was from an independent party because, as a result of this ordeal in 95, I was incarcerated for 1 year in Suffolk County House of Correction. As a result of the experience, it took a significant amount of time for me to consider a meaningful romantic relationship. I finally, in 2002, I got into such a relationship. Part of the relationship was my only child. The relationship ended in 2003. Because the mother would not allow me to see the child, I filed a complaint in the Suffolk Probate Court for joint custody and visitation. I filed this complaint April 4th of 2003. The hearing was scheduled for May 13th. On May 5th, the mother of my child went to Dorchester District Court to obtain a restraining order. The excuse used, the affidavit states that I came to the house and said, if you don't sign a piece of paper saying you grant me rights to see my daughter, I'm going to kill you and one of your kids. They issued the restraining order, the ex parte restraining order. I received notice of it. On the 9th and on the 16th, I tried to reschedule the order because I had a hearing in Taunton District Court for disorderly conduct for an event hangout with a friend at the nightclub. The clerk at the time, Leslie Martinez, refused to allow me to reschedule the hearing. I couldn't be there, so they issued a restraining order. At the time, the justice of the hearing was Rosa Miller. She was aware from a motion for a new hearing that I filed that I couldn't be there if I was in Taunton District Court. They extended the order for 1 year from that date. So I filed a motion to dismiss and vacate, which came before another judge, Timothy Gale, and again, violation of case law as well as 209A. He extended the order a year from that date, which gave a lifetime of 13 months. Now, I don't mean to keep going all the names, but the problem is that as first justice, I brought all these issues to Justice Hanlon, and she is just outright said, restraining order from June 18, 2003. I was denied the right to file a notice of appeal for the clerk, Leslie Martinez, refused to allow me. For 3.5 years, I was denied an appeal. Repeatedly, I contacted First Justice Hanlon, the clerk magistrate, Anthony Owens at the court. I filed actions in the appeals court, trying to force Dorchester District Court to assemble and forward the record to the appeals court so I could fight the restraining order. In 2005, I finally had to take the matter to the federal court for violation of my constitutional rights, due process rights. It was at that point that the record was finally assembled and forwarded to the court. So, on June 18, 2003, June 18, 2004, December 16, 2004, and December 16, 2005, those 4 hearings, I have never been granted an appeal. December 15th of 2006, a permanent restraining order was issued. And again, in violation of firm case law as well as the statute. During the interim part of that, in 2005, I went before the SJC. Now, this can be considered indicative of the state of mind of the Commonwealth of Massachusetts. I went before the full panel of the SJC. Chief Justice Marshall specifically asked me, well, why are you doing here? Because the requirements are that you go to the appeals court first. I said, I can't. I try to go to the appeals court. This court won't forward the record. The appeals court says they won't take it out the record. And their decision, which is recorded, Chief Justice Marshall said the matter is dismissed because he should have went to the appeals court. So I was in catch-22. And I only bring these issues up to show that Justice Hanlon has been able to continue this abuse of office and discrimination against men because there's been no checks and balances. There's no repercussions, just like any other abuse of office. And unfortunately, this led into a campaign of harassment, not only by other clerks and other justices of Dorchester District Court, but other branches of the Commonwealth. Since 1995, any criminal offense an individual commits against me, the case is dismissed. In 2002, the uncle of the mother of my only child made pedophilic actions to her 3 sons. We had a physical altercation, he lost. The next day he came smashed all the windows on my truck. There were more than a dozen people in the area, as well as photos of the incident. Suffolk County DA's office dismissed the matter. The ex was calling me and had stolen my property again. The case was dismissed. Very briefly, and I want to bring documents, physical documentation to support everything I say. Very briefly is that I feel that this would be a bad selection because, despite the others, I have personal experience that a male does not get partial interpretation of law before Chief Justice, before Justice Sydney Hanlon.
Thank you very much. At this time, we're going to break. The Lieutenant Governor, I believe, will come in momentarily. I could take you folks and stay here. You can go outside, but we should resume.